Let's start. Good afternoon, Ms. Kooverjie. You must just tell me whether I'm pronouncing your surname correctly.
You are. Good afternoon, Acting Chief Justice. Good afternoon, Commissioners.
Thank you. Welcome, and thank you for availing yourself for this interview.
Thank you.
Yes. According to the questionnaire, you hold the degrees of BA and LLB from VETS, is that right?
Yes.
And you got your BA in 1990 and your LLB in 1993.
Yes.
Why do you hesitate?
Yes, that is true. Yes, Acting Chief Justice.
Okay, and since then you also did a certificate in the law of third-party compensation, and you did a few diplomas at the University of Pretoria, is that right?
Yes, I have.
Yes.
They were all alternative dispute resolution diplomas in various in mediation, arbitration, and arbitrations.
And you did a negotiation and leadership course at Harvard Law School in 2019.
Yes, that was the most recent qualification.
Yes. And when were you admitted as an advocate?
In 1996.
And when did you start practicing as an advocate?
Immediately after I finished my pupillage exam.
Yes.
And those years, it was for a period of 6 months. Pupillage was for 6 months.
Yes. Okay. And have you been in practice as an advocate since then up to now?
Yes, Acting Chief Justice. I've been in practice for the last 25 years and uninterrupted.
Yes. And when did you take silk?
I was nominated for silk in 2014, but I received my latest patent in 2015.
Yes. And tell us about the types of cases you have been doing in your practice, handling in your practice over the past 25 years. What types of cases have you been doing?
Initially, when I started like the work that every other junior counsel would get, which would be matrimonial work, your normal civil matters. And I started then a little bit with labor work. And then as I got into a few years into my practice, I then focused a little bit more on labor and tax work. And that was because I started receiving junior briefs from the Office of the State Attorney to be a junior counsel in tax matters. And then I did tax matters up until 2008. And in that period, before 2008, in the early 2000s, I started getting exposed to various cases which dealt with administrative law. And after 2008, my practice then took a turn into the financial sector laws. As I was appointed on the appeal boards of the Financial Services Board. And 3 years later, in 2011, I was also appointed on the Financial Intelligence Center appeal boards. So with that, coupled with that, I started doing less tax work, and I continued in this field of law together with many matters in respect of administrative law and related constitutional aspects.
Yes. And are there cases that you have done which have resulted in reported judgments?
Yeah.
That is cases you have done as an advocate where you have appeared and argued them, and they have resulted in reported judgments.
Yes, Acting Chief Justice, I did list some of them in my application.
Yes.
Do you want me to refer to them? I've listed, I think, about 15.
About 15, no, that's good enough. And have you acted as a judge in the High Court?
Yes, I have been acting since 2013. I've been acting on the invitation from the Judge President.
That would be on different occasions?
Yes, on different occasions since 2013.
And are there any judgments that you have written during your acting stints that have been reported by any chance?
I haven't marked them reportable, and when I tried to locate my judgments specifically for this interview, I got most of them on Safely and other sources, so I'm not certain if they were actually marked reportable.
Yeah, no. I was not asking about those that you may have marked as reportable. I was asking about those that were, as a matter of fact, reported. So you say you don't know, you have not seen any that have been reported.
I was probably remiss in that, Acting Chief Justice. I didn't double check if they were reported.
Yes, okay. And in the High Court, you have, when acting, you have done civil trials, criminal trials, motion court, opposed and unopposed, is that right?
Yes, I've done all the courts.
Yes.
Besides criminal, besides the full court, I think the full court, I remember I did one, I had done a full court matter with other senior judges, but I couldn't locate the matter. So yes, I've done all the courts.
Yes. And in your practice, did you do criminal work at all, even
Yes, initially, Acting Chief Justice, what I did was, as a junior, we were recipients of pro deo briefs. So in my junior years, for at least the first 5 years, I often would march to the criminal courts to, on the legal aid briefs and represent and appear on their behalf. I then didn't do purely criminal trials, but I was involved in various tax matters, particularly the one where there was search and seizure warrants that was executed in respect of various accused. And in those matters, I dealt in detail with the search and seizure warrants in terms of the Criminal Procedure Act. And so that is where it stopped in my practice in terms of criminal law.
Yes. And have you done any matters as counsel in the Constitutional Court?
Yes, I have, Acting Chief Justice. I did one in 2019.
Yes. Okay. Judge President Lambo.
Thank you, Acting Chief Justice. Advocate Kooverjie, I hope I'm pronouncing it correctly.
It's, yes, JP, it's Kooverjie.
Oh, Kooverjie. Okay, thank you very much. I think one of the questions that the Acting Chief Justice asked you relates to your alternative dispute resolution qualifications. Is it correct that you've been involved on the PABASA platform of introducing an international mediation training program that ended last week?
Yes, JP, it's correct. I had brought this course to South Africa, and I've asked the international trainers to please do it for our South African audience, specifically our lawyers or our legal practitioners, and they agreed to do it, and they did it at no cost.
And you invited judges, and judges were part of the training as well?
Yes, there were a few judges that were part of the training. There were also employees from the Legal Practice Council, and there were various other independent advocates, attorneys, as well as people out that were not part of the legal fraternity.
Yes. I think looking at your spreadsheet, I see that you've done a total of 9 weeks in the opposed motion courts, 17 weeks in the unopposed motion courts, 10 weeks of civil trials, and then the others are scattered throughout. Would you confirm that?
Yes, I do, JP.
Thank you. Any particular work area that gave you a problem?
Well, initially, in the initial years when I started acting, it wasn't the areas of the law that I had difficulty in. I think it was the volume, specifically in the opposed motion court. At the time when we started with, when I had started acting, on any given motion court, unopposed motion court week, sometimes we get up to 80 to 100 files. So I found that daunting, but it wasn't the complexity of the matters that I found difficult. It was the volume of the work. But thereafter, acting regularly, as you can see, I've done many weeks in the unopposed motion court. I managed to manage my time and execute those weeks with success.
Just clarify the 80 to whatever files. Is that per day or per week?
It's per session. So if you have an unopposed motion court 3 days in a week, a Monday, Wednesday, and Friday, you would get anything between 80 to 100 files for Monday, 80 to 100 files for Wednesday, and 80 to 100 files for Friday.
I see. And in the opposed motion, just give the commissioner a sense of how many you get per week, because that one is the weekly allocation.
That will also depend on how the matters are allocated to you and how many matters would come normally on there. And over the years, initially would get anything between 8 to 12 opposed motion matters. Sometimes there'd be a little less and sometimes a little more. So I'd say the maximum to about 15.
Yeah. I think what helps is the pro bono acting judges that come. That accounts for less allocations. Am I correct?
Yes, JP.
Thank you. And your judgment spreadsheet tells us that in your 49 weeks of acting, you've written 49 judgments.
Yes, JP, that's according to the list.
45, sorry.
45, yes.
Yeah.
That's according to the list that I prepared. And I must at this point state that when I did my application and submitted my application, there were lesser judgments. It is during the course of my preparation that I actually found more judgments. So there were those that I had prepared, that I had handed down in my earlier years, and I managed to come across them either through the websites, and that is why they now amount to 45.
Yeah. And your judgments cover almost a wide spectrum of areas of the law. Am I correct?
Yes, JP, it does.
And my last question, Acting Chief Justice, is that you've only delivered 2 judgments beyond 3 months, and that was 1 day after the 3-month period for both of them. Am I correct?
Yes, that was one was 1 day after, and the other one was 2 days after. I think if I remember correctly, it was matter number 35 and 36
Yes.
from that spreadsheet that I've given you.
So you've had no problem actually meeting the 3-month deadline?
No, not at all, JP.
Thank you very much, Acting Chief Justice. I'm finished with this candidate.
Thank you, Judge President. MEC Lesotho, if you have got questions, please go ahead. MEC, are you there? He is not there. I'll go to the commissioners and I'll try again later. Commissioner Dolo Lepu.
Thank you, Acting Chief Justice. Good afternoon, Advocate Kooverjie.
Good afternoon, Commissioner.
I have to, that's why I raised my hand first. I needed to declare she's one of my LPC councillors. So before we go forward. But
I guess that must mean you must ask her very difficult questions.
Yeah, I have to. So what I wanted to, I wanted you to tell the Commission that you are one of the advocates who really supports the legal practice, the legal sector code, and what are we envisaging with the legal sector code, because you are part and parcel of that committee.
Thank you, Commissioner. I believe that it is only with the promulgation and with the of the Legal Services Sector Code, which is a code in terms of the BBEE Act, in terms of Section 9 of that Act, which the Legal Practice Council was tasked and mandated to provide some code in order to ensure that there is transformation in the legal profession, that there is access for legal practitioners to practice in the sector. And the Legal Services Sector Code was one of the major projects that we undertook as the Transformation Committee. And it took us many hours, many months, and after much deliberation and collaboration, we managed to finalize the code. And what I believe that we will be able to achieve from this code, from the Legal Services Sector Code, is that we will at least force individuals, public sector, as well as state organs to contribute to transformation, to comply with the prescripts of transformation. Transformation is very slow insofar as the legal practice, insofar as the legal profession is concerned. And by legalizing, if I use the word very loosely, it will eventually force everyone to participate. And we will then have a watchdog, which will be the Legal Services Council. And that watchdog will be able to monitor whether transformation is taking place. And there has to be then, there would be a commitment to transformation.
Thank you, I just wanted to brag.
Yeah, okay. I'm told the MEC is back. He was disconnected. MEC, Lesufi, if you are back, I give you a chance to ask questions if you have questions for the candidate.
Thanks, Acting CJ. The system keeps kicking me out, but I'm back. But I'm okay. I'm fine, Chair. I have no questions. Thank you so much.
Okay, thank you, MEC. MEC Nokesi.
Yes, MEC. I am the MEC. Look, I just follow up. I just follow up on this question.
I'm sorry, Minister.
Okay. Thank you.
Yes.
I'm just following up on this question.
Yes, Commissioner.
Of the Legal Sector Code. I understand that there were members of that council, of the LPC, were opposing the process leading to the Legal Sector Code. What is do you know what's the basis, or what is your comment on that? To those who were opposing an instrument meant to transform.
Well, Commissioner, from my understanding in our deliberations at council meetings, there wasn't that inherent there wasn't a sentiment expressed that they were opposed to transformation. I think what the objections raised were the manner in which the transformation, the code was developed, and the manner in which a code was developed, and as well as the content of the Legal Services Sector Code. That is what was posed in our deliberations at council meetings. Whether, in fact, they actually opposed transformation, I cannot confirm that.
Thank you, Commissioner Nokesi. The Minister would like to do a follow-up on your question.
Yeah, no, thank you, Advocate. I can state that we can't wait for the DTI to gazette the code. It's at an advanced stage of gazetting. But I want you to speak for the benefit of the public watching, including the members of the profession, who could be asking themselves, then what will happen to those who fail to comply with the sector code? Because one of the biggest criticisms of the codes and the charter is the failure to comply with its target.
Thank you, Minister. Good afternoon to you. The Legal Practice Council and the Legal Services Sector Code is aimed at various fora of legal practitioners. It includes state organs, it includes the private sector, it includes the corporates, in all of those environments, and if there's non-compliance with the legal services sector code, those entities will be disadvantaged. And I say so because we know that the state is the biggest procurement of legal work. And most of these corporates and private entities and other bodies are actually subscribed to state work in any form, whether it's an investigation or whether it's actually representing the state organs. And those are and if they do not comply with the legal services sector code, then they would not be able to get that type of work. Now, when I say what these big corporates or private sector entities are supposed to comply with, is that they should actually they should meet all of the generic code requirements, which means that they need to show how many black directors they have, what is the capacity of their briefing patterns, whether they use black counsel, and the like. I'm not sure if I answered.
Yeah, no, thank you, Acting CJ.
Thank you. I wonder whether it would not be convenient for you to ask your own question that you covered. Oh, that's good news. Commissioner Schlemmer.
Thank you, Acting Chief Justice. Good afternoon, ma'am.
Good afternoon, Commissioner.
I've noticed from your questionnaire and your not your publications, your qualifications, that you're quite interested and involved in alternative dispute resolution. And I also note that one of the support letters indicate that you introduced what the gentleman calls a confidential clerk system at the AFSA arbitrations. Can you tell us to what extent do you see alternative dispute resolution and the courts, the functions, and specifically the aspect that with arbitration, normally you don't have published awards, and how that influences the development of the law in the country, and the fact that you are introducing younger colleagues to that. How do you see the two balancing out?
Can I just ask you to rephrase that question? I understood most of what you were asking, and I just want to know exactly the last bit that I missed.
Okay, so there are two
yes.
aspects. The one is that alternative dispute resolution is important in your view, I suppose.
Yes.
And that is why you want to expose junior people to it, and therefore the introduction of the confidential clerks. Linked to alternative dispute resolution is the lack of legal development because the awards are not published. How do you see that the judiciary and alternative dispute resolution then assists in the legal process in the country?
Maybe insofar as alternative dispute resolution is concerned, it's a wide concept. So it includes mediation, arbitration, and even negotiations. Where it can benefit the judiciary or the courts is that we need to perhaps encourage mediation. We need to encourage mediation so that litigants don't come into court cold-faced. They are actually placed in a position where they are able to try to resolve. They are in a position where they can resolve their own disputes. And what we should actually do is maybe put in practical make it practical in that we should actually establish mediation officers and also provide mediators to assist the litigants. I'm not sure if that is what you were really wanting, whether that was your question.
May I follow up?
Yeah.
It's not really only relating to mediation, also the issue that with arbitration, which is different from mediation, you get awards that are not published most of the time.
Yes.
And if you are dealing with complicated financial law issues or with banking law or with commercial law, sometimes the law would have benefited if that was dealt with in a court of law, because then you might have created legal precedent. in arbitration, you don't create legal precedent.
Yes.
So how do you see that the two are interlinked or not interlinked at all? What is the benefit of it?
Well, we know that arbitrations are confidential, and that's why you won't have the awards published, or does not become public knowledge. So, and we also know that over the years, many litigants have taken matters out of court and rather resorted to arbitration for various reasons. And maybe what we need to do is get those matters back so that they can be adjudicated in court, and then you can have a judgment, and would then be for the public benefit.
Thank you, Judith.
Thank you. Before I go to President Meyer, let me go to the commissioners on the virtual platform. Commissioners on the virtual platform, is there anyone who has a question? There is no one. Thank you. President Meyer.
Thank you, ACJ. Good afternoon, Ms. Kooverjie.
Good afternoon, President Meyer.
My other question, substantive question, has already been asked. Now, I just want to find out from you about this complaint that has been lodged against you by a certain Mr. Mokone.
Yes.
Alleging professional misconduct and seeking the striking off. What is the status of that complaint?
President, I had prepared a written response, and I'm not sure that whether you had actually received it, but maybe I can just brief you into that response. There were two complaints by Mr. Mokone against me. The first one dealt with the issue concerning the Legal Practice Council, because I sit as a council member. In that regard, there was a memo that has been circulated stating that those allegations are unfounded and have no merit. And we know the reason why Mr. Mokone lodged that complaint was because he was upset about the fact that he's been taken to task, he's been suspended, and there was an application to remove him from the role of attorneys. In respect of the second complaint, from what I could decipher from his complaint is that he's requested reasons. He stated that he requested reasons from me after I had delivered judgments in his matters. I state that I did not receive any request from him for reasons to date. If I had received the request for reasons, I would most certainly have given reasons. I had also in my memo set out the circumstances under which I had granted the orders. Again, in respect of Mr. Mokone, there were private matters. He was actually the applicant, and he failed to attend court on the occasion that the matter was set down. I granted him the indulgence and asked him to furnish a date where he would be available, or his counsel will be available. They gave a date, and he still did not attend court. The matters were the orders were. I had given them orders then. I dismissed the applications, but he has never requested reasons, and that is the genesis of his complaint.
Thank you. I'm satisfied, Ms. Kooverjie. Thank you, ACJ.
Thank you. Commissioner Tsepe.
Thank you, Acting Chief Justice. Good afternoon, Council.
Good afternoon, Commissioner.
I just wanted, having gone through your application and your CV and in some of your response to the complaint, I wanted you to take the commissioners through some of the transformation initiatives that you have introduced in the chambers where you are at. Thank you.
Yes. In respect of the chambers, or in respect of the bar and the chambers?
Both. Thank you.
Yes. Well, let me start with the first issue that has already been raised regarding the confidential clerks. I am currently the chair of the Arbitration Foundation of South Africa for the Pretoria branch. And over the years, I've seen that arbitrations do not come the way of our black colleagues. So what I've undertaken in this, as a convener of the arbitration committee and chair, I've taken it upon myself that every time I recommend an arbitrator, it has to be a female or a black, a female and black silk, or at least a black silk or a black male member. And in instances where there are not black silks, then I would give it to female silks. I would very carefully and cautiously give those matters to white silks. That's the first project. The second project is that I've undertaken and formed a junior committee in our building, the Club Advocates Chambers. I have seen the plight of our juniors. They cannot even afford to pay bar fees. I have currently now, at this moment, I have got about 12 matters where I actually have juniors deviling for me, and I pay them out of my own pocket because clients do refuse to pay juniors, or they actually do not want to take on juniors and incur further costs. I have also, since we've moved in 2018 to the new group, myself and the late advocate Sami Labala, and I do mention his name with a lot of reverence, had undertaken and approached various organizations and institutions, private law firms, and we collaborated with them in order to make work available to our juniors, specifically those that are commercial matters or those that are specialized fields of those matters that are specialized matters. And that is some of the tasks that I've undertaken insofar as my transformation objectives are concerned. I've also initiated, and with other members, we've initiated and we finally managed to adopt a transformation policy at the Pretoria Society of Advocates. And this was accepted by all, including the 50% AFT representation who sits on the Bar Council as well. There's just so many projects that we've undertaken. We also invited all of these institutions to come and speak to our juniors, to upskill them on specific areas of the law. I can go on.
Thank you,
Okay, all
ACJ.
right.
Thank you, Councillor.
Thank you. I think we have reached the end of this interview. Thank you very much, Ms. Kooverjie, for availing yourself. You are now excused.
Thank you, Acting Chief Justice. Thank you, Commissioners, for your time. Thank you very much.
Thank you.